It sounds to me from some of the people I've interviewed so far, it wasn't uncommon in the mid to late 40s to become an associate to a judge, and you were just mentioning Bernard Sugarman before. So basically once you'd completed your law degree, did you go straight to becoming an associate to him?
Once again, I did it through Bob Ellicott. Bob had, you're quite right, it was very usual, and I think probably still is, for many young people intending to go to the bar to spend a year or so with a judge as an associate. And Bob had been Bernard Sugarman's associate the year after he graduated, which was a year ahead of me. And it was he who said to Bernard Sugarman, you need an associate next year, what about Trevor Morling? And that's how I came to be his associate.
What was Bernard Sugarman like? I've read articles about him in the archival papers, but I'd like to get a little picture of Bernard Sugarman.
He, many people would have regarded, and with some justification, as a bit of a, I'll use the expression, stick in the mud. He was a very quiet man, he incessantly smoked. When I say smoked a pipe, had a pipe in his mouth. It rarely had much tobacco in it, but he was reserved, but a very good friend to me and to other people. I think he was properly I suspect, well regarded by other judges. My understanding is this, that his first appointment, which would have been made by Dr. Evatt, to I've forgotten what it was then called, the Federal Industrial Commission or Court, was a straight political appointment in the sense that he didn't, I think, have much to do with industrial law, but was well regarded as a cerebral lawyer. I suspect he didn't really enjoy that work and was transferred to the Supreme Court mostly initially doing what was the work of what was then called the Land and Valuation Court, where I came to see a lot of him because when I left him, the one bit of work which I did know a bit about was the work of that court. And people I got a few briefs there, and I was appeared in front of the Sugarman J quite frequently.
I'm interested, you were mentioning earlier enjoying the theatre, as it were, of the court up at Darlinghurst and seeing criminal lawyers practising their craft. Yet you were going yourself into a rather different area of law. So I wondered, what was pivotal in you deciding not to do crime?
I don't think I actually decided initially not to do anything. I was looking for anything I could get. Indeed, I remember to this day that in my first 6 months at the bar, I got almost no work, and I grossed in income a total of £27. So you can see that I was not rushed with work, and I would have did take, like most young blokes, anything that came through the door. I went to the bar thinking and hoping to become an equity lawyer.
Which was quite prestigious.
Yeah, but I didn't get much of a go at that sort of work initially. I did get some, but I did get some land and valuation court work because of people thought, well, if he heard a year of it, there was almost nobody else doing the work. But I did get, as I got further into the bar, a fair share of equity work, partly because I got to read almost with, if you use that expression, with Ray Else Mitchell, who had a huge equity practice. And again, I got that introduction through Bob Ellicott, who was very much exclusively into equity work and were reading things and writing draft opinions for Ray Earls Mitchell. So, but then I did, as I became a more senior junior, I just wasn't getting any or getting very little criminal work. I did do a bit, but you tend to, I think, be carried along by the tide in some respects. Well into my practice years, after I took silk, I started to get some quite significant industrial work, which I never ever thought I'd be briefed in, but I used to be briefed well after I took silk by the New South Wales government in industrial work. But that was just, a bit of an accident, if you like,
I wonder, nevertheless, you mentioned the tide that took you. I wonder, though, your temperament seems to have been suited, nevertheless, to that tide.
I think so, yes. I don't think I had the advocacy qualities which was then thought to be a good thing to have doing criminal work. I did the occasional criminal work. I found it very stressful. I found, in the sense that, I'll never forget, that only in the days when the offence of rape carried the death penalty, I was briefed by a law school friend. I'd just been through law school to appear for a bloke in the country. He'd gone into practice in the country to defend a fellow charged with rape. And the worst thing you can do, I found, was to really believe your client was innocent, because I said to myself, well, look, if this fellow gets convicted, it'll be my poor advocacy, which is, and it's a terrible responsibility, was to me. It's certainly in those days, I think by those days, the death penalty was always commuted. Was pretty close to not proving it wasn't commuted, but so it was I found it a great responsibility that you, in a criminal case, even more than in a civil case,
No one I know in those days wanted to see the judge put the black cap on.
No.
And if you're an advocate, I did read about a well-known woman advocate in Melbourne, Joan Rosenove, and it's a lovely description of this chill of sickness that she felt when the judge put the black cap on, she knew then her client was lost.
Yes, well, I have to say, I didn't have much of a criminal practice. I only briefed in a couple of murder cases later. But even in a case where your client was, I use the expression, only going to go to jail, you were concerned, but particularly if you felt that he or she shouldn't. I can remember one case. I wasn't going to mention it. Don't know how it got the brief, but there was a woman who was a madam of a brothel. This is the quality of the legal work I got in those days, who was charged with really soliciting young women to become prostitutes. And I was totally convinced, and indeed she was acquitted of that charge, that the charge was just put on her by the police because they wanted to get rid of her in some way.
It wasn't Kate Lee, was it?
No, it wasn't Kate Lee, but I've forgotten the name, but I do remember the case, was that she was sent up to my chambers by the solicitor. This happened in those days, sort of without any decent brief, any decent statement, and she had no statement. She told me an oral account of what her defence was, and just as I'm talking to you now. And I had to go to court. She came up early in the morning and I said, look, will you stay in my chambers, sit down and write out or type out, she could type, she was an intelligent woman, attractive personality. And when they came back hours later, she had this written, coherent statement. And I remember that, although it must be 50 years ago plus. But I do remember that rape case which was heard in Narrabri Supreme Court. It was a country case. That was a real worry.
What was the outcome?
The outcome was the jury retired about 4 o'clock, and it stayed out till about 10 o'clock at night and acquitted my man. I felt very convinced. If people don't realise the different atmosphere which surrounded migrants in those days, this fellow was a German migrant. And if you were a German migrant in 1952, you thought you were probably an ex-Nazi, which probably would have been wrong, but you didn't make a favourable impression in front of a jury if you were a German migrant. And his case, which I felt was, his story, which I felt was correct, was that it was a case of consent or no consent, and our case was consent, and the jury agonised about it, and you can imagine how I felt for the next 6 hours when they were out deliberating, deciding whether they were going to convict him or not, and they came back about 10 o'clock at night in Narrabri Supreme Court and acquitted him.
Yes, there was a lot of prejudice about what was called refos in those days.
Yes.
So you would have felt, indeed, relief.
That's right. You're quite right. Refos was the term which we all used, which was wrongly used. My own view is, there's nothing to do with the law, the great wave of prosperity which Australia experienced in the 20 or 30 years after the war was very much due to the refos. They came in, if they were painters or bricklayers, they worked hard and they got on, they would get into business and they would work, to get a business going. And I think Australians by and large were too relaxed not to be bothered with doing that. It was the migrants who came in who led the way.